begin with our last in-house technical session number 13. The session is titled Why International Law Matters. It's chaired by Professor V.G. Hegde, Professor of International Law and Chairperson at the Center for International Legal Studies, SIS, JNU. He also taught at the Faculty of Legal Studies, South Asian University. Before joining JNU and with JNU, he held senior positions at the Asian African Legal Consultative Organization and Legal and Treaties Division at Ministry of External Affairs. Thank you, sir. Please, over to you.
So we start. Okay. Wish to thank the school and also the dean and all the other colleagues, particularly who's been organizing this. And this is the last technical session, as already been mentioned. And now we are discussing the topic why international law matters. This is the last session of the entire seminar, which debated for last 4 days the various issues concerning why international relations matter. I'm not sure whether this is deliberate or our seminar organizers felt that international law could be the last resort to resolve differences, disputes and conflicts among states. One of our colleagues, I think Dr. Archana Nagi, yesterday told me, when I said this, she said, you should only say international law only matters. I quote, and of course because she belonged to our center in initial stages, so still holds the so that's the on a more serious note, in domestic legal systems, I just going to make some initial remarks, and then my colleagues of course will take over later. So in domestic legal systems, legal step is a sort of a last resort. I mean, I said last resort, it is a really last resort actually. If you take into account your, in case at home or elsewhere, something happens and nothing happens, then you decide to go to the court. So that's the last resort. You don't want to go to court, but you will go to court or take legal means only when actually nothing happens. So a last resort step to be taken when everything fails. It's not so in international relations context, actually. We have been working in the intersection of international relations and international law. Obviously, I'm going to point out some of these issues. International law is one of the many options available to the state parties. Whether to take recourse to formal or informal kinds of resolution of disputes or differences, conflicts, and such similar things is a political decision to be taken by the competent state authorities. Let's be very clear about it. In case if India wants to go to International Court of Justice or elsewhere, it is not an entirely a legal decision to be taken by the Indian Supreme Court. It is the political decision actually to be taken by the at the highest level. All the way. So both international law and politics go hand in hand. They need to support and supplement each other in building a peaceful, more humane, inclusive, and more predictable world. At least that is the ideal. That's how generally the governments, even including the legal division or the various territorial divisions within our own ministry work in that sense. International law operates within a complex, sometimes unpredictable international political system. The vagaries of this system is there to see for all of us. I don't want to explain. So does international law really matter to such a system? That's the first question. I think that's why we call why international law matters, but still, does international law really matter to such a system? Because this question is being constantly asked in recent times actually. The first issue for consideration is domestic law, which is called municipal law under international law, interchangeably, but generally international law terms, domestic law is municipal law. And international law they both operate, domestic law and international law. Let me put some of the basic things clear. They operate in a very different spheres actually. They don't meet each other. So Usually nothing can supersede domestic law, which includes the constitution and its principles in any given state within its territorial limits. We should be very clear about it. In India, in case if there is anything within Indian territory happens, it is the Indian law which is supreme. Nothing, international law doesn't matter if you ask me. Up to a point it does matter when Supreme Court speaks about something, etc. Same thing in other countries also. There is nothing. Even in the US also it's same. Domestic law also could extend technically its arms through extraterritorial application of its regulatory framework. President Trump, for example, and since it's very recent, I'm giving you this example, is using this principle of extraterritoriality in applying internationally the American domestic law. Basically, tariff acts and several other legislations within the US context have been enacted to give effect to extraterritoriality. Trump is not doing anything new. The tariff acts are there, then there are USTR, United States Trade Representative. If you go to the website, you can see a number of legislations which actually allow Section 301 and all this, which have been very widely debated within the World Trade Organization as well. The legality of these acts have been debated. There are panel and appellate body decisions on this. All this is American domestic law actually. Whether American domestic law is legally correct or not is something which international law can also decide. But there cannot be a sort of a finality on this issue because it's American law and the Americans only have to amend it or change it. There cannot be a sort of a, so supremacy of domestic law is important. Next point is international law, on the other hand, operates in various ways within the bilateral or multilateral context as it is invoked by states. The most important thing, sovereignty principle is the key in determining the effectiveness of international law. The increasing globalization and the inevitability of interconnectedness among states requires it to self-limit its sovereignty. That's the key. Sovereignty is there, but it's mentioned that states self-limit themselves actually. States consent themselves to limit their sovereignty. There is nothing like absolute sovereignty in the present state of international relations. International law has to operate within these complex allies and gullies to be effective. State conduct needs restraint and mutual, that is reciprocal perhaps, acceptance of obligations. So international law provides the framework for this conduct. States usually comply with international legal norms, albeit with very limited exceptions. Just take account. The whole regime of I'm just giving you an example why it's effective actually, why it matters. I'm just giving you some examples. I'm sure these are quite well-known examples. The whole regime of state and diplomatic immunity, it operates. Obviously, you can see it's quite well entrenched. Nobody can stop it from operation. Sanctity of treaties and agreements, pacta sunt servanda. This is a basic principle which all countries agree and apply. Of course, obviously some can say I'm going to get out of the treaty. India has got out of investment treaties, 85 of them in 2016. Trump is doing it. He said he's out of WHO, he's out of criminal court and things like that. So that's okay. That's the state's prerogative to do it. Treaties provide for it. So there is no problem about it. But these are predictable actually. And the whole regime of diplomatic immunity, treaties and agreement, respect to territorial integrity, boundaries that are contested and disputed bilaterally could be understandable exceptions. The whole regime of law of the sea and international maritime practices, the principle of permanent sovereignty over natural resources, limits on transboundary harm in the context of international environmental law, which Sujith is going to speak. The biodiversity related issues, traditional knowledge systems, traditional cultural expressions, the WIPO has been working in recent times. The whole issue of regulation of global regime on intellectual property rights, TRIPS, I don't have to mention about it. The international trade agreements, related regimes, the international humanitarian law that seeks to ameliorate, soften the effects of war conflicts under 4 Geneva Convention. The list is unending actually. These are all being applied in recent times. You have talked about Gaza, you have talked about Ukraine and Russia. All this law is, and the International Court of Justice has given a verdict actually on these issues based on the basic understanding and principles of this. Of course, there are areas of divergence between states that need longer gestation time to evolve. such as international criminal law, for example, defining crimes at the global level, conflicts such as aggression. There was no definition of aggression for a very long time. Even today, there is no concrete definition of aggression in international law because states don't agree on any definition. Crimes against humanity, war crimes, and international terrorism. So there is no definition per se because the only international statute of the International Criminal Court could able to define up to a point, but still there is a whole lot of divergence between states about defining this particular thing, because this includes not only law but also includes politics. When you talk about terrorism, there was one point of time, there were subjects within the United Nations Sixth Committee, they debated on the one group's, you can call them terrorists, but at the same time the other group would call them as national liberation movement leaders. Actually, there is a whole lot of conflicts that exist within the United Nations system as well. Now let us go to the more difficult issues. These aspects of international law, though have been codified after prolonged negotiations, continue to challenge the existing world and global order. The adoption of the United Nations Charter, for example, by a certain number of powerful states at that time, sought to provide fairly a firm edifice for the ever-wobbling international system. The UN Charter is regarded as a both political and a legal document. The World Court, the International Court of Justice, has said that at least in 6 cases, they have said it's both legal and political document. We can't give a totally legal verdict unless and until certain political dimensions are taken into account. Because in case if there is a problem, for example, when they give a wall advisory opinion regarding Israel some 2010, it was the United Nations Secretary General's report which actually formed the basis for the decision of the World Court. So it's both political and a legal document. Its existence, operation, success and failures highlight the bonding that existed between international politics, international relations and international law. The first 2 articles, that's Article 1 and 2 of the UN Charter, clearly embodied the basic accepted norms of international law that are to be followed in conducting international relations. These are, for example, of course in recent times, these are in the great news: to refrain from threat of using force against territorial integrity and political independence of states, not to interfere in domestic affairs of another state, to settle all differences and disputes through peaceful means, to cooperate internationally to sustain peace, and so on. These are all there in Article 1 and 2 of the UN Charter. For over 7 decades, we have seen emergence of several international institutional frameworks put in place by states to maintain peace and order. The UN Charter further underlined in its preamble the challenges that exist in maintaining peace and order in the world, and today it is most important because you can see that how the Charter principles are actually being followed or violated in the current context. For international law, there are some interesting facets to this. I'll just explain to you. There has been a great debate, but I thought, when we say why international law matters, I think these debates have to be put before you to understand the whole problem. For international law, states are its main subjects, though international organizations, individuals and host of other entities are all now slowly entering its regulatory ambit. So states still hold the sway, but still there are others who are also in the subjects of international law. The first important point to be noted is that international law is created by states and adhered to by the states. That's number 1. There are a number of factors that result in the transgression of international legal norms by states. Even then, states continue to justify their acts of commission and omission through the lens of international law. So you see, Putin came on the TV and explained why he is going to Ukraine just before doing so. The Bush, when he went to Iraq, he came on TV, explained why he did so. You can see, they justified it through the whole lot of United Nations, legal principles, etc. They make a statement. The war is an instrument of state policy. International law does not prohibit war, only regulates war. Use of force, that's the word used. So use of force is a prerogative of the states. So obviously there is no prohibition in the history of international law, but whoever goes to war actually will have to explain. But still there are a number of small and big sort of conflicts there. You find that states keep doing it but may not explain. For example, if you take Africa and other smaller conflicts, this kind of thing is not followed. But in the larger ones, you will always say that the leaders come and explain their international legal position. This debate about transgressions by states began way back in 1960s and 70s itself. For example, Professor Thomas Frank, very well-known international law professor, wrote an article in American Journal of International Law in the 1970s titled, "Who Killed Article 2.4 of the UN Charter?" The title of the article in American Journal of International Law, "Who Killed Article 2.4?" 2.4 is refrain from going into the threat of using force against territorial integrity, etc., etc. This was violated obviously by the great powers, actually, that point of time. This was Professor Thomas Frank from the New York University, that point of time, wrote this fantastic article, and it was followed by several articles, actually. And then these states come back and go to collective security system, talk in Security Council, and then number of articles again have been written in various very major international law journals. The titles are very interesting. The 9 lives of Article 9 lives, like cats have 9 lives. The Article 2.4 has 9 lives. Death of Article 2.4. So there is a whole lot of articles about this particular problem that existed. The question remains unanswered even today, and the Article 2.4 conundrum continues unabated. Article 2.4 refrains states from using force, etc. I've already mentioned. That debate has continued over and over again. States continue to violate this basic principle but try to justify their actions under international law. I need not give examples of these violations and justifications given the contemporary conflicts that are being raged as of now. I'll just take 2 minutes and finish. The efficacy of international law is dependent on the good faith adherence to its normative universe by the states. Like any normative principle, whether it is within a national or an international context, international legal principles are amenable to more than one interpretation. States, as is the wont, as is the practice, invoke that interpretation in defense of their actions under international relations that sustain their national interests. So when you have more than one interpretation, you will take that interpretation which suits you, actually. But now there are international legal norms that are regarded as erga omnes obligations from which states cannot derogate. So there is no interpretation about these erga omnes obligations. And the least of these erga omnes, these are called, norms from where you can have no derogation, has been enlarging in recent times. There are a number of norms which have been enlisted, which are increasing in slowly, but still states actually find ways to overcome and then actually take recourse to whatever action they want to take. The last point, all these norm creation process under international law usually takes long time to evolve. Let us be very clear about it. For example, Law of the Sea, United Nations Convention Law of the Sea took almost 5 decades. Entire international reverse regime took more than 3 decades. GATT and WTO, we have been talking about it for the last few days, also took over 70 years, actually. The GATT came in 1948, WTO came in 1995, and then you have so many rounds, and all that actually took more than 70 years. There is nothing like instant international law. There is nothing like instant coffee, instant international law. But except when Ben Chung, one of the Chinese international law scholars, wrote in Indian Journal of International Law way back in 1970s, argued that existence of such instant international law in the space-related issues. Outer Space Treaty, when it was created, he said Outer Space Treaty and all these resolutions created instant international law because all states agreed to it. When all states agree to it, there is unanimity state practice, then it can become he argued, but of course there is still, I don't think there is an instant international law. The soft and hard law distinction is unique to international law. Soft law because that accommodates all kinds of state interests. The identification of the sources of international law itself is a challenge, though we have treaties, customs, general principles and others under Article 38 of the International Court of Justice. This is still being debated. The states need time to accept and adjust their domestic regimes to implement their obligations under international law. So there is this viewpoint that Professor Annie Mary Slaughter from the US and Koskenemi, Anthony Angie, Professor Chimney, Professor Gati, and several others have spoken about fragmentation of international law. And the Professor Annie Mary Slaughter, writing in Harvard Journal of International Law in almost early 2000, said the future of international law is domestic. Just look at the changing Indian domestic laws, for example. Give the Indian domestic law. Look at Indian domestic laws, arbitration law, IPRs, labor laws, trade and competition law, company law, cross-border insolvency, all the human rights, criminal laws, several others all have imprint of international law. Today, if you open arbitration law, it is based on international law. The preamble says that it is taken from the United Nations Framework Convention. If you look at labor law, that has also labor code, ILO conventions are actually influencing them. So there is an imprint of international law. So I firmly conclude that it is not just the question why international law matters to be answered in the affirmative. It does matter. However, we need to question the process of norm creation. What could be termed as international law-making process? It's most difficult. In the post-colonial, the post-Second World War context, new states had no role to play in international law norm creation. So majority of these new states remained at the periphery of this process. So we need to question such process, and such process should become more accommodative and inclusive. This will enhance the efficacy of international law and its effectiveness. In other words, international law should matter to all states, big or small, rich or poor. And will that happen? That's a question mark. That perhaps needs separate consideration. Just these are some of my thoughts I wish to raise, and look forward to my colleagues who are going to make more detailed and sectoral presentations with this small sort of introductory remarks which I've taken. Yeah. It looks small. I request Vinai Singh to go ahead.
Thank you, sir. Let us set thanks to Dean SIS, Professor Damattu, Chairperson Professor V.G. Hegde, and senior professors like Professor Varun Sani, my other colleagues, Dr. Raj Yadav, Paridaji, Dr. Paridaji, and many other colleagues who have been present in this August gathering. This is a great opportunity to speak or present in Kunzru Memorial Lecture. It has been basically one of the prestigious events in the SIS since my student times, and we aspire to be part of it. And today's my presentation will be on aspect of enforcement and compliance in the panel Why International Law Matters. And I will argue in this 5 to 10 minutes that international law today becomes the one most strategic weapons to be used, has been used to what you can say, resolve the disputes. And let think about, imagine how would the World Bank, or how would the world without no UN Charter, no diplomatic immunity, no WTO, no international human rights regimes, no law of the sea conventions. And often that which appears to see this, why international law matters, often been centered towards the debate about the compliance enforcement exists in international law. And it has been, since long, it has been central preoccupation in international legal scholarships. It is often commented that international law is not a law, international law is a weak law. And often we in classes spend 1 hour to explain the relevance of international law, why international law matters. Despite that, international law does not have a sanction behind it. And often we refer to the several scholars digging it that how the international law regulates the behavior of the states, though not directly impact in such a way that to be immediately enforced it. And Several scholars in last, what you can say, last 70 years, if you dig, written on very extensively on. Some of them I will refer just for our students' knowledge, that it would be very important to see those writings, and even title will suffice the purpose to say why international law matters. It begins with Thomas Frank, Fairness in International Law and Institution, where he argued that fairness within international law is the one which has been state away. It's from the South, global South. It could be a challenging to say on that context. But Harold Coe, why do nations obey international law? Then Eric Posner and Goldsmith, who argued for the limitations of the international law, and reply is very interesting reply from the Robert House, Beyond Compliance, Rethinking Why International Law Matters. In all these, what you can say, literatures which you could see the emphasis being on to explore the compliance and enforcement regimes in international law. Now, coming to the recent times and putting the argument that the tools of international law has been used in recent times to take the cases before the international courts and tribunals, and it has been strategically done, and it has become a tools what today is known sometimes is known as a lawfare, as a warfare to defeat your opponent on certain point of issue. Need not to mention that a very huge corpus of international law has emerged nowadays. It's become difficult to comprehend each one of the, what you can say, enforcement and compliance mechanism in terms of it. But gradually these compliance mechanisms, enforcement mechanism in international law has been, what you can say, extensively used by the states. And recent times, if you look that the Ukraine has used international forums, international dispute and settlement mechanisms, several occasions against the Russia. It begins with what you can say, along with the Netherlands filing a case for downing the MH17, then taking the course to the WTO dispute settlement measures, where they challenge the Russia's measures with related to tariffs. Then they're taking the matter with related to genocide. Then parallel interstate complaint mechanism has been brought by the brought by the Ukraine against Russia in the CILS committee. Earlier, it was never thought that CILS committee would be a teeth to be resolved the dispute along with the line what you can say global conflict issues. And the recent time, the CILS committee has been used extensively by states. Even Qatar has used when their air route was blocked, or discrimination has been done against the Qatari citizens. Another point which you could see in recent times, the disputes where the mass intervention from the states in a disputes has been seen into it, including Palestine and Palestine versus South Africa versus Palestine case, where 41 states made intervention in the disputes pertaining to what you can say the crimes of genocides. So the over the years, what you could see these forums have been used extensively by states in the terms to use the international law to defend their rights, to exercise their rights. And another important point you could see in this context, that there were certain concepts which were been initially was been there. It was never been relied for standing before the courts, like Sir has highlighted erga obligations or just cogence principles. Earlier times, these concepts were never been used as standing before the courts. But you can see South Africa has brought a case against Israel, which has no way been affected with the what is happening in Israel. Then you could see Gambia has brought a case against the Myanmar, where the Gambia has to argue that how they are relevant before the case courts for this case. So these concepts of erga just cogence, which has been initially in the textbook, has now been operationalized. And very many of the common concerns point which has recently been used. My colleague also will highlight about the, what you can say, some of the concepts which have been considered the common concerns of mankind or humankind in environmental law would be recently been used in that context. So, one for Indian context, India also been at present moment is being exploring several ways to use the international law. And you know, all of us know very well that Jadhav case when brought against the Pakistan, and we found that there is one optional protocol which provided for compulsory settlement of disputes. And that was being become for us to save this Jadhav from the what you can say from the trial for the trial for his against death penalty. And besides this, another point which is useful for all of us to focus on it, that international law is gradually displacing the municipal legal system and municipal policy. This has been advanced, this idea has been basically, what you can say, advanced from the our Center for International Legal Studies, Professor R.P. Anand, Professor Khan, Professor Chimney, who has been basically extensively work on this Asian approaches to international law and TWAIL, where he found that several Western projects has been gradually been included into the international law and need to be countered from the alternative perspective of the international law. Another important aspect which I would like to mention here, that interpretation of Article 2(4) subclass 2, Article 2 subclass 4 and Article 51, which together constitute about to determine the legality of the use of force. And recently, a doctrine which has been propounded by the West, unwilling enable doctrine, which is being become to justify the surgical strikes in a conflict situations. And India has also used this Balakot surgical strikes, but India has yet to basically make a formal take on that, whether it could use the unable or unwilling doctrine to justify the surgical strike. So I will end here with this some comments on it.
Okay, thank you, Vinay. I think it's you gave an overview of how India also is looking at international law, particularly in relation to the disputes, and then some of the basic principles. Now let me request Fazil to continue discussing. He's going to tell more about international organizations. Yeah, please go ahead.
Thank you, sir. Good afternoon, everyone. This afternoon is great pleasure to be here and my dear students as well. So today, my esteemed colleagues have already referred to the empire of international law, where we have the spatial expansion of international law has given birth to a virtual empire of international law itself, where you have these connections between domestic and international law taking place, and it's also creating the conditions in which these relations between states could be taken up further, and where the vocabulary of international law is utilized for the purpose of thinking about and also dealing with all types of international relations problems and opportunities which are there for cooperation at the interstate level. So I want to focus upon this role and function of the International Court of Justice and broadly within the judicial function in international law. We know that international law as a discipline has been engaged with this the organizational dimension for almost 2 centuries now. We have from the Concert of Europe onwards, there were a series of institutional mechanisms which were developed to deal with the incremental problems in different areas of international life. Initially, it was about the interstate cooperation which was required for the international rivers in Europe, Danube, Commission and others which were established way back in 1856. And before that also, 1815, it started. So the institutionalization and administrative unions which were developed essentially for technical cooperation, to uniform standards were developed for that purpose, for the facilitating the globalization which was taking place at that point of time in various areas, especially because of the invention, the intellectual property rights, copyright, and other types of international law documents, instruments came into the picture at that point of time. And this process was taken up even further with the establishment of the League of Nations and subsequently the emergence of the United Nations after. And in between we have two world wars where once again the horrors of the war made it convincing, for the international community, the need for coming together for peaceful settlement of disputes. And that's where international courts came into existence at that point of time. In a number of experiments were done, especially in South America, for instance, way back in the beginning of the 20th century itself. We see that there were efforts at the regional level for coming with international courts. And we have, with the establishment of the Permanent Court of International Justice, along with the Covenant of the League of Nations, we have a solid international institution which was looking at interstate disputes on the basis of international law, on the framework of international law. They were willing to look at these issues. And it also facilitated further the establishment of international organizations with a distinct legal personality. ILO was already approaching the Permanent Court of International Justice in the 1920s, asking for legal opinion about how to conduct their own affairs without conflict, how to resolve those issues peacefully. And that was taken to another level with the establishment of the United Nations. So there is a linear progressive narrative we see in the literature when we talk about international law. But after the establishment of the United Nations, along with the Statute of the International Court of Justice and the compulsory settlement of several disputes under the framework of the UN Charter and the Statute of the International Court of Justice, we also see that these were essentially technical matters and not really political matters which were getting resolved within the framework of international law. So international law has got certain expertise in relation to its technical functions of creating cooperation where willing states are available. And if states are willing to come together to find a solution, then it is able to provide that kind of a solution to the community at large. If not, then there are all kinds of problems. So this is where this tussle between whether it should remain as a technical discipline or it should look into the political dimension, the justice orientation, which is required, is where the much of the theoretical debates have been going on. The positivist tradition was always looking at only the technical dimension, how to resolve those problems in an amicable way through the instrumentality of law and legal process and institutionalization, how we can come to the settlement of disputes. But the new approaches to international law, especially by the third world scholars, a number of them have been engaged with the promise and limits of international law in that sense. And especially this was in the context of the decolonization process. We have with the establishment of the United Nations and the principle of right to self-determination of the peoples. And the subaltern peoples in Asia and Africa, with the 1960 declaration of granting of freedom to colonial peoples in Asia and Africa, it's a very famous UN General Assembly resolution, which talked about it. And in that 20-year period, between 60 and 80, we have seen a number of international law scholars who were arguing and making to change, to bring about change from old international law into a new international law, from the colonial vestiges within international law, which was preventing the international community from exercising the justice orientation and the moral dimension of international law. So they wanted to bring about change. They wanted to look deeply into the structures of international law. And they wanted to establish whatever is possible within the framework of the institutionalization, where the General Assembly provided that opportunity for majority of states to come with their own resolutions. But these were, again, fundamental legal doctrines which were established in the times of the colonial era, created trouble. And that is why we did not get to a logical conclusion of the new international economic order or the Charter of Rights and Duties and other documents which were produced at that point of time by third world scholars. They could not really come to the logical conclusion of to creating an alternative vision for the global order. We have to remain within the framework of the international law as it existed. I'll give one example of the way in which the International Court has dealt with this problem within the context of decolonization. I'm talking about the issue faced by the island state, a small state called Mauritius, which we are all familiar with. Last decade, there were a number of, Mauritius became independent in 1968. And since then, it has been trying to get access to the territory where the Americans have the Diego Garcia naval base is located. Essentially, what they have done is, just before giving independence to Mauritius, the UK as the colonial power seized the territory, detached the territory from Mauritius and gave it to the Americans through a bilateral agreement among themselves. So 5 years or 3 years before independence, Mauritius lost a part of its territory. And the people who lived there were en masse taken out of the place. They lost that territory altogether, and the people lost their right to return to their own territory. They have been going to courts in UK, US, European Union, everywhere. Wherever the Chagosian people are there, you can see that they have mounted legal defense wherever possible so that they could go back to their own original land. That became impossible under the framework of this interstate arrangement that they have made. Then Mauritius waged a number of legal battles, including at the International Tribunal for the Law of the Sea, when UK established something called Marine Protection Area within the framework of this Diego Garcia Island area. And Mauritius wanted to utilize this framework of UNCLOS, the UN Convention on the Law of the Sea, for having access to this territory for its citizens. Once again, it did not go further, and then the issue was brought before the UN General Assembly, and the General Assembly asked for an advisory opinion from the International Court of Justice. So under the statute of the International Court of Justice, the court can give advisory opinion on contentious matters as well as on all legal questions. It's possible for the International Court of Justice, if it wants, it can give advisory opinion to UN institutions, specialized agencies, especially if it is requested by the UN General Assembly or the Security Council, or any of the other specialized agencies of the UN if they come through with the acceptance of the UN framework. So the advisory opinion rendered by the ICJ said that the way in which the independence was granted and subsequent detachment of the territory, Chagos archipelago, was done not in the way in which it is expected to be done. The right to self-determination of the Mauritian people was not really respected by this kind of detachment of a part of the national territory. And so it is a violation of international law, and measures should be taken by UK. And it was a clear embarrassment for the United Kingdom to know that it was called before the International Court of Justice to answer this question. And now we have a sort of solution coming up, although it is an imperfect solution, but at least something that is recognizing this place and role of a small state like Mauritius within the framework of the international legal system. So law offers, law matters for the third world, for the people, the underclass, the marginalized sections of the global community at this point of time. And they could utilize, and like my colleagues have been telling, strategic litigation sometimes will be useful for the purpose of for establishing the fundamental principles of international law. Like Sir has already noted, it is a time-taking process. It's a long time. By the time whether justice will be served will remain a question mark. We have an imperfect system, but we have to continue to engage with it. We have to try to make it more accessible for more and more communities and peoples. And in that sense, sometimes the legal and technical rules need to be creatively interpreted. This is where the ergonomous obligation that you have spoken about is also useful. Like the International Court of Justice clearly stated in these cases where Gambia from Africa was taking up the case of the Rohingyans, people who are made refugees and stateless by the dictator of the state operation itself in Myanmar. So the court said that the violation of an international law like the Genocide Convention is a matter where there are international legal obligations involved, not necessarily, you don't need to have a personal, a state level interest for that purpose to come before the international court. If your international legal rights as available under multilateral conventions are being violated, a state can go before the International Court of Justice. So for the first time in 2019, there is a subtle change in the legal process whereby it became possible for states to make this avenue became open for the international community, especially for states who need international law for their defense, for their independence, for their progress. So in that sense, there are creative interpretations and spaces available within the framework of international law. And I believe in that sense, it's useful to engage with it. And I don't see any other alternative except anarchy and chaos when law is not available to defend the rights of the least defended. Thank you.
Thank you. Thank you, Fazil. Now I think I'll just go over to Dr. Sujith. He's going to speak to us.
Yes.
Yeah, go ahead.
Thank you, sir. Thank you, Dean, and thank you all colleagues and students. I know that we are running really short of time, so I'll be extremely brief, and I'm going to tell you only half of the things which I plan to, and I would be happy to elaborate if there are questions. Because in the last half an hour or so, we have heard quite a lot about how international law is important, and we managed to positively and affirmatively answer why international law matters. And my colleague also said that it's about the empire of international law, but there's also like a slightly counter narrative to it. A counter literature about it, a counter theory about it. It also says international law for empire. That's also there as a counter narrative, counter theory. So what I'm going to do is to take a little bit of that in the light of a small story that I have been following up in the last couple of years, and that's about climate change litigation. Because often, in the literature, we see that there is a sudden explosion of climate litigations at the international level, at the regional level, even at the local level. Because a vague statistics say that there are about or more than like 3,500 climate litigations pending as and when you and I are speaking here. And most of the predictions say that it is going to exponentially increase in the coming years. So this is the larger context in which we need to understand, or we need to assess that, okay, why international law matters, and how to understand this question and how to examine this question rather than, finding an answer to this question. So what I'm going to do is that, to look at this sudden explosion in climate change litigations, and rather than trying to read most of the literature, mainstream literature, it says that this is where I think the marginalized countries have faith in international legal order, international law and judicial institutions, so on and so forth, and they are going there for justice, etc., etc. But there are plenty of literature about it. But taking a slight deviation from that narrative, we can also see several interesting dynamics in that whole process. It's not just about justice, it is not just about a dispute, or it's not just about getting some quick remedy out of it. But in some cases, the idea is much larger than that, and quite a lot of politics also involved in that, the mere process of approaching various judicial institutions for this purpose. So I'm going to quickly, 5 minutes, I'm going to throw very broad 3 points, and then I will stop at that level. The first part is the way I look at it, it leads to some sort of what we can call as a democratization of making, implementation and enforcement of international law. Because this whole process, directly and indirectly, it gives an opportunity for many non-state actors to participate. This is surprisingly unconventional, because international law is known for being so state-centric, and it tried to ensure the kind of monopoly of states in this whole process. And here it is actually non-state actors are participating in it, and in a very creative way, and sometimes in a reactive way as well. So this is the first point. And many people have already started calling it by name, borrowing from various indigenous traditions, Andean traditions, because a friend of mine wrote a whole of literature about it and call it as, by borrowing a terminology from Andean tradition, saying that it is Minga, which means collective production. And the lawyeristic terminology is juridical Minga. That is what they try to call this whole ongoing process. Whether it's actually that or not is a debatable question, but some sort of collectivity or democratization attempt or participatory attempt that we can witness in this whole process. The second point is that it's again, another way in which some people describes this whole process is as the power of grassroots activism. For instance, look at the ongoing ICJ advisory opinion on climate change obligations, which is the process is going on. Probably an opinion we are expecting sometime in 2025. So if we look at the whole root, whole genesis of how this process started, we might end up in the University of South Pacific, where there is a small collective of students. They started protesting and started demanding this, and then they managed to influence the state, and then one small island nation managed to, get a UN General Assembly resolution requesting an ICJ advisory opinion. So this is where one way in which marginalized countries and people, they are, it's not just anybody and everybody, but even the marginalized countries or small nations are trying to make some changes, or trying to use law and legal institutions for certain purposes. Whether they actually and completely achieve that purpose is a different question that we have yet to see. We need to see that. We are yet to see it. But they've started this process. It's not that they are using only law and legal institutions. Law and legal institutions are only one of the several strategic initiatives that they are taking. Right. For instance, we have seen photographs of cabinet meetings underwater. It's mainly to expose or to even invite attention. And the last problem, the last point is as far as these global South countries, and when I say global South, there are fractures within global South, where there is more South within South. So when we look at these things from those southern countries' point of view, particularly small island nations, when it comes to climate change, what kind of things that they can hope to achieve? Because many a time, we see that they are relying on this in order to get justice, but from their own narratives, justice is a far-fetched dream. It's not even a near, kind of a dream. But what they're trying to make is, this is where I would stop. They are crying, they are shouting, they are making noise. And law and legal institutions, they use that as a platform so that others hear them, others see them. It is more like a campaign purpose, rather than getting an immediate justice or remedy, which I think they also realize the fact that it is extremely difficult, if not impossible, to get quick remedy through legal processes. I think I would stop here and happy to, elaborate if needed. Thank you.
Sujith, for this brief but very precise presentation. I think we can extend by 5-10 minutes. I think we started a little late, I think, with your permission. Yeah, question and answers. I think it's open. Three of our colleagues have already, there are many hands up. Okay. Shall we start with you? Yeah. Identify yourself and then I'll come one by one. Then please be brief. Yeah.
Can you hear me? I'm Swapnil. I'm a PhD scholar at the Center for Law and Governance. My question is for Professor Hegde, since you mentioned extraterritoriality of laws. So I was interested to ask this question. As we know, the Indian Penal Code, like from a very Indian perspective, and also international law at the same time, that we know that Indian Penal Code recently has been replaced by the new set of codes, which is Bharatiya Nyaya Sanhita. And in section 48 of it, there is the seepage of extraterritoriality of laws, which talks about the state can persecute any person who is abetting or intending or conspiring to commit crimes outside of India within the territory of India. So I was just wondering, how does it fit within the precincts of international law, or does it not? And even in that case, just to think of it, how would the due process of law would look like? Because also BNS and the entire set of codes is also being hailed as an attempt to decolonize law, to like override the Indian Penal Code, in the sense of like the colonial codes are being taken over, the decolonization of law. So I think it's very interesting to see how extraterritoriality has also seeped into our Indian our Indian criminal code. So I would be really interested to know that. Thank you.
I'll take one or two more questions, then we can answer. Yeah, please go ahead, second one, and then next one. Please identify yourself.
My name is Inzam PI. I am a student of MA PASM. So actually there is a Greek word called pharmakon, so which has double meaning, poison as well as counter poison. So in that way, how does the discourse of human rights, which is a counter poison, becomes a poison again, especially in the context of Ubendra Bakshi's idea of, the 12 scholars. So how their approach has been successful in legal reforms as well as resistance. Thank you.
Okay. Yeah. Please go ahead, and then we'll come to this side later. First, okay. Let's take three questions. Yeah.
Okay. I am Biswit Das, PhD second year, Center for International Studies. I want to know how international law work in the International Economic Organization. I mean WTO, World Bank, IMF, that kind of organization.
Okay. So as far as just 1 minute, let me finish these three. The first one is legal advice. You need a legal advice on this. I think Bharatiya Nyaya Samhita, this extraterritoriality is inbuilt into many of the acts or provisions within the many Indian laws actually. Betting is now done through internet and then through various other means where servers are kept in other countries. So there is a complex process that is involved actually. So that within India, but the effect can actually happen outside India. Then India can actually request the other countries to help or to do whatever is required actually. So in other words, the extraterritoriality principle actually has implications in other sectors quite badly, but in this kind of a situation, I think it is more technical and more desirable actually to do that. In case if you want to, for example, a bullet is fired. This is a very simple example always given in textbook. Standing between India and Pakistan border and somebody has fired a bullet from India towards that Pakistan side. Then there is a crime which is happening. The crime actually, the bullet is fired here, the crime has taken place in the other place. So both countries have jurisdiction actually. See, because crime is happening, actually the crime where it happens has the jurisdiction, but India can have jurisdiction because it started from the Indian side. So you have that kind of a complexity that exists in law, but states will have to resolve it in terms of extraterritoriality. But extraterritoriality in terms of law, trade law and other things, it becomes a more complex issue. For example, the best case is the extraterritoriality principle. For example, in case if you want to stop somebody from exporting certain things to your country, then you bring in a law. Like for example, I'm sure there are other colleagues who can shrimp case in the context of WTO, where US came out with a Mammals Act, where it said whoever catching shrimp should actually use a certain kind of a net so that the turtles can be saved. So US said that I am doing it in good faith, but other countries they said that this is done to as like a non-tariff barrier sort of thing. So, but it's a US law. US said that whoever is not using that turtle net, TEDnet, they will not be allowed to export it to United States, so unless certified by TEDnet. So this is extraterritoriality, where you want to actually stop. Those are very complex issues. But this is not such a problematic, because the Criminal Act always can be taken care. As far as the international economic organizations, I'm sure that's a very complex, how they work, WTO, etc. I think we need to speak at a later point of time. I think it can't be answered in one session actually. But of course the basic, there are a number of issues involved. The WTO agreement is a very big agreement, got about 400 pages, 15 agreements. Then the agreement establishing the World Trade Organization, you have GATT, and then how it enters. So it is too much of an issue how they work. Particularly economic organization, they work. The problem, of course, is raised is the IMF, World Bank. Their problem is that there is a weighted voting system, which is a problem. Where that's why you always have the presidents. World Trade Organization has now from Brazil, from Nigeria, etc. Director generals have been appointed. But as far as the World Trade, the IMF and World Bank, so far either it's Europe or the United States who actually appoint them. There is a whole lot of discrimination, sort of inequity that exists within the working of these organizations. Conditionalities and all, those are things which are being debated. That's a counter which BRICS wanted to bring in. So there are a number of arguments, discussions within the international economic law we discuss. And the other question, anybody? The third one?
The TWAIL and human rights.
TWAIL and human rights. Yeah.
Yeah, unless I think you specifically pointed your question at someone here.
Anybody can answer.
Anybody? Okay. Right. Okay. See, I mean, you asked about human rights and this poison counter poison thing, and in the light of TWAIL. So as far as I understand TWAIL, I mean all these narratives are part of TWAIL, because TWAIL is not a single story, so to speak. Right, there are slightly liberal to people who are completely dismissive of human rights. All these traditions are conveniently accommodated within the TWAIL tradition, as far as I read TWAIL literature. For instance, there are mild version which says that human rights has a potential. It can be used as a tool for emancipation, progress, yes. But at the same time, on the other end, there are TWAIL scholars who argue that there is very little that we can hope. It is yet another instrument, like what I said at the beginning. It is like human rights is the empire, and empire is human rights. That is what it is. But one thing which I personally, I tend to follow is a dualist approach towards human rights, where it is seen rather than being dismissive. It is being seen as a site of contestation and resistance, and that is where I am tempted to put myself as far as this particular question is concerned.
So this side.
Sir, as it was just mentioned that there is no legal definition of terrorism. Sir, my question is that
Identify yourself.
My name is Anirudh. I am a research associate at CIPOD. Sir, my question is that given there is no legal definition of terrorism, I wanted to ask that how can the principles of self-defense under Article 51 of the UN Charter be applied to non-state actors like terrorism operating within sovereign states? without undermining state sovereignty or international law?
Yeah.
Sir, my name is Fazil Jamal, a student of first year PISL. My question is that like powerful nations are not enforcing the international law correctly. Like there is a discrimination also. Like in the case of Nicaragua versus United States case, where the US refused to comply with the ICJ judgment despite being found guilty of violating the prohibitions of the use of force and the principles of non-interventions and obligations under the UN charters and customary law. Like, does this not undermine the very foundation of international law? In the absence of an effective enforcement mechanism, does international law truly matters for weaker section, or is it merely a tool that can be superseded by a strong nation when it's conflict with their own interests?
So I'll give a brief answer to this. To say a brief answer on the Nicaragua question, see, after the main judgment came, there was an agreement between the two countries and it was settled. The financial compensation that was awarded by ICJ was granted by US to the party. So you can't say that in all cases the most powerful states are not willing to abide by international law. They pick and choose, and especially political questions, there are a lot of qualifications and problem in terms of compliance with the orders of the international courts. But in this specific case, this is how it finally ended.
Yeah, with no legal definition of terrorism and interpretation of Article 2 of Class 4 along with the 51. This doctrine, put against the legality of the use of force, is being set with the Caroline doctrine, and under that context being states, and gradually what happened that the foreign soils are being used to use force, and which has been need to be seen that how it could be within this context of Article 2 force of Class 51 can be accommodated. And the debate started with the Afghanistan, what you can say, from the West, projecting that, and also advancing national security schemes from the United States, and invoking that doctrine of unable, unwilling doctrine. When the foreign states had been asked to basically tackle or to see that their soils should not be used for the use of force against another states, and then this doctrine was being invoked by United States, and then gradually been directly or indirectly other states also had adhered it. In India context, this India, after using the Balakot strikes, made official statement but does not refer about anything about unwilling doctrine. Since this doctrine is being very, what you can say, potential to be misused against the weaker, smaller states, as you are rightly mentioned on it. So the position so far to see this doctrine getting the legitimacy through the worldwide is yet to be seen in that context. So I hope that I have answered the question. Thank you.
Just to add to what Dr. Vinai Singh said, Article 50, there are only two places in the United Nations Charter which speak about use of force. Only two. There is nothing else. Nowhere you will find in international law legitimizing use of force. One is, of course, Article 51, where legitimately you can use, and Article 51, and second is collective security. So where they can use of force is legitimized. Otherwise, but self-defense is interpreted in different ways by different states. India also interpreted it when Bangladeshi refugees came into India. The India going to Bangladesh is, they said, because this is self-defense. Article 51, self-defense was used in Bangladesh. They said 10 million refugees are within India, so it's actually creating problem for us. So that's we are going. The word used in Article 51 is imminent threat. The word imminent is actually not defined. So secondly, it's for states. Third is when you talk about non-state actors. The problem is non-state actors, if they are within a state and if they are getting actually support from the state, that needs to be looked at actually. See, now terrorism definition, because terrorism, there is a host of international, General Assembly has passed a number of, every year passes a resolution, and it has been sectoral actually. Terrorism is defined in sectoral terms. For example, they talk about the kind of violence that happens in shipping, in other areas. So it is not a definition per se as terrorism, but in aircraft related. So there is a whole 13 different sectoral definitions that are available technically, but there is no political definition per se on international terrorism. So there is a problem there actually. But states are quite happy with it because they want it to be flexible so that they can use it. So these are the two areas. So as far as non-state actors are concerned, non-state actors have to be brought in or not. The Geneva Convention Protocol 2, I think, actually is looking at it. Non-state actors, to what extent they must be allowed to be part of the, under international humanitarian law. National liberation movement. So there is and once they are actually taken in under international as belligerents, they have an obligation to follow the exact law of war actually, and if they don't do it, it actually creates obligations, and you become an occupied power. See, once you, for example, in case United States goes to Iraq and then does, or Afghanistan, when United States is there, United States is an occupied power. When you are an occupying power, then you have certain obligations which actually will entail you breach obligations. The same thing happened with Israel in the Wall Advisory Opinion, because Israel was actually managing the green line, and then entry of Palestinians this side, that side, and there was violation of human rights. So Israel became an occupying power. That's the reason why the court said that you have to pay reparations. This is way back in 2010 or something like that. So there is a whole lot of legal sort of problems. When you become an occupying power, then you have a very clear obligations. The US has an obligation in case if it has done something wrong within Iraq, even in Afghanistan. But nobody has taken US to the court. You know the reason actually. So this is just to add to what Dr. Vinay Singh said. Sorry, please. I think we can take another 5 minutes. And finish. Yeah, because people, the last session, technical session, so people are...
Well, sorry to jump in, and thank you to all colleagues. This really gave me a flavor of the Friday seminar. So I was transported to 3 decades ago, sitting and listening to international law stalwarts. So really nice. Thank you all. I just was drawn by a recent piece. So my question is basically to any of you, because it relates to the discipline of international law. There was a reference to a very famous article written by Hilary Charlesworth from a feminist perspective of international law about 20 years ago, and which she titled International Law, a Discipline of Crisis, and where she argued that this was post-Kosovo, and she said that the focus of international law only on crisis situations actually devalues the discipline. Now, a recent publication this year talks about a shift from a discipline of crisis to a discipline in crisis. And the argument there is that whereas there was a disciplinary convergence on issues of aggression, violence, war, etc., this no longer seems to be the case, and therefore is the discipline of international law in crisis. While I personally agree that international law matters, so I'm with you on this, but I just wanted a response on what you feel about the health of international law as a discipline.
Yeah. Yeah, I think, yeah, anybody? Sujith, you want to take? Yeah, I'll.
Yes.
All of us should.
Yeah, I think that's a good theme for another Friday seminar, I would say. But again, yes, just a very quick response, because I know why some of them are saying that discipline is in crisis because of some of these extraordinary events. But at the same time, one way to address that question, or one way to understand that question, is also to look at the daily life of international law. And daily life of international law cannot be, accommodated or explained with these extraordinary events. So for instance, some of my colleagues have been reading about Palestine question for last 1 year in Melbourne. And they have come up with the same kind of question, saying that, okay, because, why do we even care international law by looking at this? But the question is that, they look at only one area and one issue and then try to judge a whole legal order. But at the same time, there would be plenty of or numerous areas where I think we can find certain other things. And another thing is that, it's also a crisis where if it is not international law, and then what else? Someone in the same session in some of the previous lectures says that it is the best of the worst. Just in case if we go by this discipline in crisis thing. But having said that, I think this is something to be explored in a greater detail, but not as a general thing, but by examining quite a lot of case studies to arrive at a conclusion. Methodologically speaking.
Yeah. Now there are a number of writings have come up in various journals. Particularly European Journal has been publishing quite a number of sort of reflections on these kind of issues, discipline. And then if you look at particularly when it comes to humanitarian law implications, how it is being actually done. So particularly in the European context. So. But general issue, of course, Hriday Charsworth herself is now in the World Court, so should be able to resolve many of these issues. But after so many years, so I think I agree with Sujith, because if you look at the many things which happen around the world, daily life he mentioned, there is an article almost in the same breath written. That you look at many things which are happening around the world, the international law is actually functioning very well. If you look at IPRs, I can give you the example. But the only problem I find is not the law, how it operates. The law making is a problem. The more important problem is law making, actually, where it is not actually getting to the participatory. Only best example I will end with this. The way it should go is the law of the sea convention. Takes time, but it took into account so many complex issues. But actually, for a global regime on seas, still it works very well, and it has actually sublet many of its functions to maritime organizations, competent international institutions. But that kind of regime, no state, including Trump, cannot actually touch it as of now. Although he can say, I am going to call it Gulf of Mexico to Gulf of US, that's okay. But he can't say that he's going to go beyond 200 nautical miles, I'm going to do this, that. States have delimited themselves. They have gone to the Common Code of Arbitration. There are at least 50 to 60 cases have been resolved among states through PCA, etc. So it is there, actually, and which I think should be taken note. I think with this I end. I can see already the organizers, we have overshot the time, and I thank.
Another point, Caspian Sea Convention. They have not followed international law of sea of 1982. Russia, Iran, and 3 other states, Azerbaijan, Turkmenistan, and Kazakhstan, they invoked their own mechanism to address the law of sea dispute.
Yeah, China, South China Sea is also there. No, South China Sea issue, China also is there, but I don't want to get into it. South China Sea arbitration is a different thing. But I wish to thank all my colleagues, Dr. Fazil, Dr. Vinai Singh, and Dr. Sujith for that excellent presentation, and also thank all of you for imposing international law on all of you. Extra time. Thank you very much.